Your Worship, whilst she's calling, the copy then of the, Mr. Naim, the copy of the school book, Your Worship, page of the school book as requested. As a court pleases, Your Worship. Those are the photos that my colleague forwarded to me, Your Worship. Yes. Proceed then, Your Worship.
Thank you.
As the court pleases. Yes, on this 25th day of July 2025, case number SH233 of 2025. This is a matter between Ms. Tiffany Meek as the applicant in the bail application and the state as the respondent. The application continues to be heard in the regional court at Roodepoort, Court F. The appearances are as follows. The presiding officer is still Ms. A. Africa. For the state is Mr. Eltuma. The interpreter, if necessary, is Ms. Mutawum. The court clerk is Ms. Sangweni. The applicant is represented by Mr. N.
Thank you. The time now is 11 o'clock and we would like to place specifically on record that at the last appearance the court expressly arranged with SABC for the applicant to be brought forth timelessly. As this has now been reoccurring that we are starting this matter only at 11 o'clock. Not because the court, the state or the defense is not ready, but because the applicant has been brought to court late. Once again this morning we were phoned 9 o'clock and we were informed that there was no transport to transport the applicant. Be that as it may, the time is now 11 o'clock and we will now commence. Thank you. Off record, the court was handed a copy of the photo that was taken so kindly by Mr. Knight on the last occasion of the page with the date of the 13th of May 2025, purportedly from the school book that belonged to the deceased. This will then be Exhibit M.
As court pleases.
Your full names for the record again, please.
Neighbor Protector Koyoshi.
The court is just warning you that you are still under oath to speak the truth and nothing else but the truth. Do you understand?
I do understand what you mean.
Thanks, defense.
Morning, Mr. Naidu.
So, we ended proceedings on Wednesday whereby the school bag of Jayden was opened before the court. You confirm, say?
That's correct.
So just for the record, was the school bag tested for fingerprints or were any fingerprints lifted of the school bag?
No.
Is there any reason why this was not done?
The school bag is not the material whereby fingerprints can be lifted according to fingerprints expert.
You also confirm that the school bag was only sealed as an exhibit on the 16th of May 2025, correct?
That is correct.
Were you the person who took control of this exhibit and sealed it in the forensics bag?
That is correct.
Yeah, proceed. Thank you. Now, let's move on to the events of the 14th of May 2025. At what time did you arrive at Swazi Place?
Around 1500 hours.
Were the other police officers standing down at the scene? Standing off at the scene?
That is correct.
Did the photographer and the dog handler arrive before or after you?
I found the photographer there.
And the dog handler?
No, I never saw the dog handler.
Would I be correct in saying that the dog handler and the dog had already come to Swazi Place and left prior to your arrival?
Can you repeat that question?
Would I be correct in saying that the dog handler and the dog had already come to Swazi Place and left prior to your arrival?
That is possible.
Is it possible or is that correct?
It could be. I didn't see them. I didn't see them. I never saw the dog handler. I only learned that he was there with the dog, but I never saw him.
And what time was he there with the dog, sir?
I can go to his statement.
Please do.
All right. He received a call at 11:10 and he arrived at the scene of crime at 13:50. Doesn't state when did he left the scene.
So he arrived at the scene at
13:50,
13:50. And you arrived at 1500 hours.
around 1500 hours.
So when I asked you, is it correct that the dog handler may have arrived prior to your arrival? The correct answer would have been yes.
To you, I have answered that question.
No, you did not, sir. The question was that the dog handler came to the scene of at Swazi Place prior to you coming to the scene. That was a correct statement that I made.
That is your. I didn't see the dog handler. It's
Not-
possible that he had left because I didn't see him.
We are not on the same page, unfortunately. I'm just going to simplify it. The dog handler, you confirmed, stated under oath that he arrived at Swazi Place at 13:50.
Yes,
Correct.
yes,
You arrived at 1500 hours.
yes.
So he came to Swazi Place 1 hour 10 minutes before you.
But it doesn't say when did he leave the scene.
I did not ask you if he left. I asked you, did he arrive prior to you arriving?
Okay, earlier, or a few days ago, I have stated that the place was overcrowded. Therefore, I cannot say he was not in the midst of those people when I arrived there.
Fair enough. Fair enough. I am not, it's not a trick question. I'm not trying to complicate things, sir. You agree that at 13:50 the dog handler was present.
According to his
According to
statement,
his statement.
according to his statement, yes.
At no stage did you ever see the dog handler whilst you were at Swazi Place?
No,
On the 14th of May 2025.
yes.
So we're going to assume that the dog handler came, the dog handler and the dog carried out their duties. They could have still been there when you arrived or they left. You are unsure of that.
Yes.
Can we agree on that?
Yes.
Now, so if I had to question you on anything that transpired regarding the dog and the dog handler, you will not be in a position to refute that or to dispute that.
No, only people that were there would attest to that, to questions surrounding what transpired then.
Now, you testify that. Sorry, Your Worship. Forgive me, I didn't see right here. Thank you, Your Worship. Your evidence was that the dog and the dog handler arrived at Swazi Place. The dog was trained to pick up fluid, scent, and the dog found a pillow containing blood, correct?
I read that statement to this court.
I'm asking you, that was your evidence in chief.
Yes.
Now, this pillow was found inside Unit 13, where the accused Jayden was residing, correct?
That is correct.
Was the pillow seized and sealed in an exhibit bag?
That is true.
Do you know who took possession of the exhibit and sealed it in the forensic bag?
Yes, I do.
And who is that?
Is Warrant Officer Maisele.
Warrant officer?
Maisele.
Myself. And I'll assume you have a statement from him in the docket?
Yes.
Is there an SAP 13 entry where the bag was
Okay.
booked into the Florida SAPS? So did I say bag? I meant pillow, where the pillow was.
So what are you looking for me
I'm looking
tonight?
for the SAP 13 entry where the pillow, the exhibit, was booked into the Florida SAPS on the 14th of May 2025?
No, the people from LCRC, the exhibits they collect from scenes of crime, they don't take them to Florida. They keep them in their custody in Roodepoort. Can give you their 13 number.
So it's not taken and booked into to the Florida SAPS 13
No,
first,
no.
and then signed out and taken for forensics?
No,
Why is that not so?
that is the procedure. When they seize items from the scenes of crime, they take them to their custody and prepare the documents accompanying those exhibits and take them to FSL.
My apologies, the first time I'm hearing of that process. I was of the assumption that the exhibits are taken to the station that has jurisdiction, entered into the SAP 13, and then signed for by a responsible person and taken out of the SAP 13. Like in a drug matter. Drugs are seized, booked into the SAP 13, and then taken to the forensic science laboratory, correct?
Drugs are seized by members of the police station, not by members of LCRC. Hence, they are booked in the SAP 13 of the police station.
So Warrant Officer Maisele is from LCRC or is a member of Florida SAPS?
Is from Local Criminal Record Center in Roodepoort.
Do you have the SAP 13 for the LCRC?
Yes, I have the SAP 13 number.
No. Do you have the, not the SAP 13 number, do you have a copy of the SAP 13 register?
No, I haven't made it.
Does it's available to you?
If I go to LCRC, I'll get it.
Can you give us the SAP 13 number so long?
The SAP 13 number is 459
459
389
389.
stroke 2025. It's 459 stroke 389 stroke 2025.
So there's no photocopy of the actual SAP 13?
No, I haven't made it yet.
Would it be possible for us to get a copy even prior to the end of proceedings today? Possible?
Yes, I can make arrangements to have.
Please, sir. It'll be very important to us on a specific aspect that I'm trying to get to.
All right.
Okay. Was this exhibit removed from the scene prior to your arrival?
Which one?
There, sorry, the pillow. We're still on the issue of the pillow.
I never got closer to the room, the flat number 13, because there were already officers that were processing the scene. I only took the witness on the ground and left to the station. I have never gotten closer to where the pillow was found on that day.
So are we correct in saying you never saw the pillow personally on the day, on the 14th of May?
No, I never saw it.
Because according to my client and the various witnesses who were there, some community activists, none of them saw the pillow on the 14th of May either. You won't be able to dispute that.
Just a moment to shift there. So, Amanda, and now that it's fine, we accept the applicant is here, but now the alleged corroboration now from these members of the community, I'm not sure if they would have statements to that effect.
Because we're in a bail proceeding, my apologies if I can respond. Hearsay evidence is being allowed by the state. We are not obligated to provide sworn affidavits at this stage of the defense witnesses.
Do you have a response?
I don't understand. I don't follow your worship.
Sir, what I'm putting to you is that you confirm you never saw the pillow on the day in question, correct?
Yes, but
Why?
But people that process the scene sees it after the dog had a hit on the pillow, and the photographs were taken by people that handled the scene. I wasn't there. I never saw anything that happened there.
I totally accept that, sir. What I'm saying is that I'm putting to you is that the accused and the defense witness that may be called members of the community community activists, all that were present, some were even inside Unit 13, whilst the crime scene was being processed. None of them had sight of this pillow either. That is my instructions.
I think that evidence can be tested between the defense and people that were at the scene.
Acceptable. That's a matter for evidence at the trial. Now, the pillow was removed and taken to LCRC for testing.
From 13 to LCRC, to FSL, Forensic Science Laboratory. Yes.
And that report was received and it confirmed that there was blood on the pillow, correct?
It was compared to the blood sample taken from the deceased, and it was matching.
And the blood matched?
Yes.
Were other blood samples also taken from other individuals besides the deceased and sent for a comparison?
Well, I don't understand which blood are you talking about.
Okay. Besides the deceased blood, was the accused blood taken and sent for comparison in respect of that pillow?
No.
So it's only the deceased blood that was compared to the blood of the pillow?
Because we wanted to prove that the deceased was back at home, not the applicant before the court.
You want to prove that the deceased was back at home?
If that was the blood of the deceased that was found inside the flat, which proves that the deceased was back at home.
Does the report contain any evidence to say that the blood was fresh?
No.
So if I were to put to you that my instructions was that Jayden suffered from nosebleeds and that on a continuous basis his nose used to bleed at night on a hot day, the blood could have been there from 6 months prior to your arrival or the seizure of the pillow. You can't dispute that, correct?
If you're an expert to that field, I cannot dispute
No,
that.
I'm telling you what my instructions are, sir. My instructions are that if I were to put to you that my instructions from the accuser, Jayden suffers from nosebleeds, and that if he's during the night or on a hot day, his nose bleeds and he went onto the pillow, and it happens, the last incident happened in December 2024 during the summer, you can't dispute whether that blood was fresh or it was from 6 months ago, correct?
I cannot agree with you because how the blood looked on the photos, it looked like if it's something that has been there for long, it would have faded, but the blood was you could see the blood. It was not the blood. I'm not an expert to say it was there for how long, but if you are a human being that is looking after your things, I don't think one would have seen that blood there. There must be ways that have been made to clean that blood.
That's your opinion?
Yes.
Now what I'm asking you is, did you confirm you never saw the pillow on the day in question?
No, I only saw the pillow on the photos. Not
You
on
cannot stand there and categorically state that the blood was fresh, correct?
No, I cannot.
Did you ever see the pillow after it was seized by LCRC?
No.
So you cannot testify that the blood is fresh or the blood is stale, correct?
No, I cannot.
Thank you. Was the pillowcase ever recovered?
Pillowcase?
That goes over the pillow.
No. I only heard about the pillow. I have never heard of the pillowcase.
Because the accused will testify that every pillow in a house had a pillowcase. But there's no pillowcase in the photograph that were shown to the court.
That is her statement. I don't know how did the pillow, the condition the pillow was found, whether was it covered with the pillow cover or it was found as it reflects on the photo. I cannot tell you whether was it. I think there's people who can attest to that if that information has to be tested before this court.
Was a pillowcase ever seized by the police or LCRC on the day in question?
I've never heard anyone talking about pillowcase.
Was there any pillowcase seen? Or did you you said you never went
Yes,
into Unit 13 on the 14th of May, correct?
yes, that's true.
That is by your own choice, or you were not tasked with the docket?
The docket was not yet allocated
Correct, that's the word. So therefore you never entered Unit 13?
on the 14th.
And you confirm there's no pillowcase that was seized?
No.
Or sealed in an exhibit bag or sent for forensic
No,
inspection?
I only saw the pillow.
Was there any bed sheet that was seized by the police,
Yes.
sealed in the bed sheet?
Yes,
Did the bed sheet contain any blood?
yes.
Why is this the first time we're hearing about a bed sheet? You never testified to this in evidence in chief?
I didn't know that I had to reveal all the investigation that I have in this case.
No, but
I,
you testified about the pillow and the mattress.
Okay, there was then.
Was the bed sheet tested?
It's still by the lab.
So that's inconclusive at this stage.
Yes.
Yeah, proceed, Your Worship, or is your motion to give? Now, the community, you said when you arrived at 3 o'clock, there was a lot of people there. Can you give us an estimation of how many people were at Swazi Place when you arrived?
I cannot tell, but it was a lot of people.
Estimate, we're not going to hold you to it, I promise.
It's like the number of the people in this gallery. I cannot tell you how many people are here.
Use your assumption. Look at the gallery, make an assumption. Approximately how many people do you think?
I would be wrong if
We're not going to hold you to it, sir. It's totally an assumption. If I look at the gallery and I assume there's 10 people per row, there's 50 people in the gallery, it's an assumption. Now, were there more?
Yeah, there were more than this.
There were more than these people.
Yes.
Maybe 100, less than 100, you can't say for certain.
No.
Correct? It's an assumption. If you're not sure if the gallery is testifying or wants to assist the witness. Thank you, Your Worship. So it's not to trick you or anything. I'm just saying that there was a lot of people, could be more than 50, less than 100, 200 people that were there. Correct?
It was a lot of people. That is all I can say. If I must say 1,000, would I be right?
You won't be wrong either, because it's an assumption. Let's move along. Thank you, Officer. Sir, did you see members of the public or the accused family or community activists inside Unit 13 when you arrived?
Inside what?
Inside Unit 13, the
No.
accused and Jayden's place of residence.
No.
You did not see them inside,
Inside Unit 13, no.
because you never went to Unit 13.
Yes.
So if I were to put to you that they were the accused family members, the accused herself, and community activists, some other members of the public allowed into the flat, you can't dispute that?
No, there's people who can tell you that, people who were processing the scene can tell you, but what I know is the scene was cordoned off. No one was allowed to just jump. That is a standard procedure when you're handling the scene. You cannot let people go in and out of the scene.
But you cannot dispute whether people went in and out without your knowledge. Correct?
No. I cannot tell you anything about what transpired at Unit 13. Hence, I told you that I was on the ground when I asked the applicant and the mother security for us to go to the station where I obtained the statements.
Fair enough, sir. Your Worship, I just have leave to approach the accused. Thank you. Now, there's a report from the dog handler, correct?
There's a statement from
A statement under oath from the dog handler.
That is true.
Does the statement reflect that the dog picked up a scent and went to another flat in the building besides unit number 13?
No.
Nothing at all?
No.
Now, there's a very respectable and highly trustworthy person that I had the pleasure of meeting in the last 2 weeks. She's also a community activist in the Roodepoort area and surrounding areas. Her name is Natalie Solomons. With her permission, I've been allowed, or she's given me a consent to mention a name. She belongs to the Women Empowerment Platform. Are you familiar with her?
No.
You've never heard of her before?
No. I see people by sight. I may know the person, but maybe I don't know the name.
Okay. Which is very active in the community. I thought maybe you all had interactions or you worked with her in the past in other matters.
No, I don't know the name. I may have seen the person, but I don't know that name.
You know of the group of people she represented?
Who?
The woman, Natalie Solomons, the woman.
I said I don't know.
Oh, you don't know. Sorry, my apologies. Okay, so Ms. Solomons is a well-respected, hard-working community member. In fact, she's done some incredible work. I've actually taken the liberty to actually read up on her and follow up on her. So Ms. Solomons was present on the day in question, from the 14th of May. Actually, she was at the scene. I'm not sure if it actually went into Unit 13 on the day, but she made a video that was made public on most public platforms, where she stated, and there's actually in the video, the dog handlers and the dog seen in the video, where it says that the dog picked up a scent and went up to a flat in Swazi Place, not the accused flat, but another flat. Maybe, I think I'm subject to correction, but the accused and the family have not been back there. I think it was unit number 28 or thereabout, where there's an actual video where Ms. Solomons, who I would say is a very trustworthy source, and she's not going to lie on social media. Your Worship, I'll move on. I'm not going to get to praise Ms. Solomons. But Ms. Solomons states that the dog handler and the dogs went up to the top floor, went outside a room or another unit. There was a strong scent, and the police refused to go into that flat. And I'm not lying or misleading you, sir. It's all over social media. I'm sure millions of subscribers already saw that video. And Ms. Solomons is actually present in court. So if I'm misleading you, she should have already stood up and objected to her name being used as being misleading you.
Now, Your Worship, just there, it's fine. But then this needs clarity. How many dog handlers were there? How many dogs were there? You know, is she talking? Is this trusted Ms. Solomons talking about the same dog that the witness was speaking about? Because my colleague was very quick to want to now show that there were many people. So is it the same dog?
Defense.
Thank you, Your Worship. Maybe the witness will be able to assist us.
Maybe you must ask the question.
I will, Your Worship. So, besides the dog handler statement you have who arrived at 13:50, were there other dog handlers called to the scene? Any other dog handlers that opposed to affidavits?
Only one dog. The one that I read a few days ago. Must I go back?
No. Please don't. We're just trying to get clarity for the purpose of the record.
All right.
So, to the best of your knowledge, there was one dog unit that came to the scene at Swazi Place on the 14th of May. There's no other record of any other dog handler or dog unit that was called by you or any other member of the police, correct?
That is correct.
So if Ms. Solomons made a video depicting that dog unit with the dog handler, the dog itself, and made a complete video stating that the scent was taken to another flat besides the accused flat, that would be a true recollection of the events that you are not aware of.
I think that
Your
will be
Worship, before. Yeah, but is it the same dog? I still ask, is it the same dog?
Let's accept it was one dog, the name of the dog was Ace. But that's besides the point.
Thank you, Your Worship.
That's
Your Worship,
besides
that's also a matter for evidence and
Yes.
science, but it's based on
No, what you are doing is you are trying to put the assumptions made by Ms. Solomon and her understanding of what is now playing out
Okay.
as fact. But that's just her assumption. Do you understand?
May I approach the
Hold on,
accused?
hold on. Now you're asking this witness to speculate on her assumption of what she's perceiving to play out in front of you. Do you understand?
I understand, Your Worship. I'm
Sound
just trying.
right?
Thank
No, I
you, Your Worship.
understand.
Thank you, Your Worship. Your Worship, the reason why I can't put it to the witness is because my client also only arrived after the dog had already conducted that search.
Yes,
So,
so let's move along.
we'll
because
move
it's
along.
going to require the witness to speculate. And
As a
clarify.
copy is totally understandable, Your Worship. Now, so we're going to move on to the finding of the child's body. Now, according to my instructions, the report that was given to the applicant and her family was that Jayden's body was first found on a flight of stairs, almost the same level as the parking lot. You've been to Swazi Place on numerous occasions?
Yes, yes.
So, just for the court, who I'm sure, and Mr. Duma, who's not been there, neither have I, but I've been told, when you enter, there is the parking level. You enter through, past the guardhouse, there is a parking lot. You go up about 5 steps, and there is a first level of the ground floor.
Floor,
A
yes.
ground floor, correct? Then you go up 2 flights of stairs. Like it's about
Understand.
8 flights, and then another 8 steps, another 8 steps, and then you come to the first floor where Jayden and the applicant resided.
Yes.
Now my instructions are, when you come to the parking level, you go up the first 5 stairs. Jayden's body was found on that floor, the ground floor.
That will be a misleading statement.
Okay. The guard, the night shift guard, I'm not sure if he carried Jayden himself or with the assistance of other tenants or residents. Thereafter picked Jayden's body, carried him up the 2 flights of stairs and placed him on the first floor, close to where the applicant and Jayden resided.
That is not true according to the night shift guard.
Jayden was found wearing either underwear or black shorts. And because it was cold, one of the tenants provided a blanket that they wrapped Jayden in. And he was further moved from the top of the flight of stairs to almost 2 meters in front of the applicant's doorway. Are you aware of that?
According to statements given here, that is not true.
Now, your testimony was that he was found almost 10 meters away from the doorway, correct?
I have given estimation of between 8, around 8.
8, we'll take 8. Now the applicant stated that when she arrived, Jayden was almost 2 meters away from her house.
I
So if
was,
she stepped out and walked 2 meters towards where the stenographer is seated, Jayden was lying there when she arrived.
I was not there. People that gave statements, they were clear as to where did they found him when they arrived, when the family arrived.
Okay. Now, If I could refer you to statement A7.
So it is therefore the contention of the client that when the body was seen by her, it was lying in the walkway basically.
Yes.
No longer on the staircase.
It's no longer the
It's
staircase.
now in the walkway.
About 2 meters from her door.
Yes.
Yes, Your Worship. If I could refer you to statement A7, page 5. It's a statement of Ntamu Ndunda.
What's the exhibit?
Your Worship, sorry, statement A7. Oh, exhibit K. Paragraph 9, sir. Are you with me? Page 5, paragraph 9.
Yes, I'm there.
Can you read out paragraph 9 for the record, please?
On Wednesday, 2025-05-14, at about 6:15, I was speaking to one of the tenants of complex about missing child. The tenant of Unit 8 came to where we were standing at the parking lane and said she suspected that she saw a body or something on the complex stairs, and she was not sure what was it, and I must go and check on the stairs. And I ran to last floor of the building, and I didn't see anything. And the tenant of Unit 8 told me to come down on the other floor, and that's where I saw the body of that missing child. And I then shouted that I found the body to get the attention from other tenant. And the missing body was naked, only having a black short, and it was cold, and I asked the lady of Unit 8 to bring anything to cover the body. And she then came with a small blanket and put the blanket on him. Another tenant also came to where the body was and went to the body. And the mother of the missing child was called by one of the tenants who was around.
Just read the first sentence of paragraph 10, please.
On Wednesday, 2025-05-14, at about 7 o'clock, the mother of the missing child and the family came, and they took the missing child to hospital.
That's right, sir. That's right. Okay. So, would you agree that it was not the guard who first found Jayden? It was the tenant from number 8, correct?
That is correct.
She alerted the guard
Yes.
that she had seen or found Jayden.
No.
Not that she found a body, sorry.
Yes.
Now, do you have a statement from the tenant from Unit 8?
Yes, I do.
Is there anything relating to where Jayden was found first, prior to him being moved?
Must I read?
Yes, please, if you found the relevance.
Okay. What she says here is that at about 6:25, she walked her son to the gate where his school transport collects him. As I walking down the first set of stairs, I saw something like an object revealed on the dark passage of the wall way of the complex on the same floor that I am staying at. When I arrived at the gate, I found the security who was on duty talking to other lady who I don't know her name. I heard them talking about the missing child, and that lady said the child that missing was on the same school transport with his child. I then asked the security what they did about the whole incident, and he said the incident was reported and the police came the previous night and
Okay,
said
it's fine. That's all right. So the guard says that it was 6:15 when the incident was reported to him.
yes,
Your witness from flat 8 says it was 6:25, correct?
yes,
And the guard under oath said that the applicant left at 05:30, correct? The applicant left Swazi Place. She walked off into the dark at 05:30.
says who?
The guard, your witness, the night shift guard, Mr. Ndunda. He stated that the applicant arrived at 4 a.m. and she left at 05:30, correct?
That's correct, but I need to give some clarity on that one.
So you cannot testify for other people's statements. Under oath, Mr. Ndunda stated that the applicant arrived at 4 o'clock, it's in the OB entry, and she departed at 05:30. Is that correct?
Let me check Ndunda's statement.
We went through this on Wednesday, sir. Good audience, sir.
Oh, there's people are talking about different times, and yes, it's 5:30.
5:30. That was the applicant departed from Swazi Place. And your witness from Unit 8 that found Jayden's body only found his body at 06:25, correct? 55 minutes later after the applicant left Swazi Place. Correct?
You're talking only of two people, and there's a number of people here talking about times. So
Yeah.
there is evidence to times, and these time frames, I think they can be tested because
Yes.
it's not only these people that are talking about these times.
We will
There's-
test that at the trial stage, sir. We had bail application, we testify. I am cross-examining you on your evidence, on examination in chief that was led by Mr. Duma. Do you agree?
But you're only asking me about certain people. There's people that gave statements
Yes, I am.
about the time. There's people talking. People are having their timelines. Therefore, you're focusing on one time now. You're reflecting to this court as if the times that are right are for certain people and other people are not important to say anything about their times.
Sergeant Deco, with all due respect, I have the utmost respect for you. We've spoken outside of this courtroom. Sir, you agree that as the defense attorney, I have no copies supplied to me of what is contained in the police docket at this stage.
You've been receiving copies.
Yes, only exhibits that have been used by the state in your examination in chief. You agree?
I'm even afraid about those copies that you've been receiving because now you are misusing them. I believe
not, sir.
you were provided with those copies for bail application, not for the time will come for you to be testing what you are testing now.
The basis of cross-examination is that I've got to cross-examine the witness on his testimony and try and either rebut it or prove otherwise. You agree?
I understand.
Now your evidence, the state has supplied us with these statements based on your evidence and your testimony of certain witnesses that are in the docket. I have no knowledge, or prior to me cross-examining you, we were never supplied any of the witness statements. So I am saying that according to your witnesses that you intend using at the trial, your witness deposed under oath, unit number 8, tenant.
He's not the only witness. That is my problem. Now you're relying only on one person, and there's someone that's talking about time. So hence I was asking, should I reveal all my witnesses about the times?
Going in circles.
Okay,
Unit by-
your worship, I'll leave the argument. Okay, Mr. Deco, was there any other witness beside the tenant in unit number 8 that found Jayden's body?
No.
So we have to assume that the first person that saw Jayden on that morning was the tenant from unit number 8, correct?
I need to clarify this in answering your question. When your applicant was inside her flat at 5:30, someone left.
Okay, sir.
No, I'm talking about time. We're talking about 5:30.
Right.
Someone left at 5:30.
Right.
There was no child there.
Okay.
And the applicant was inside her flat number alone, which is something that you have forgotten to tell this court.
No.
She was there alone. That one, you have never mentioned it. Whenever you talk, you say, my client, yes, I confirm, here is the bold proof that she was there. But you forgot to mention that she was not only just there, she was there alone, of which that is something surprising to me. She's been with her family. All of a sudden, she is there alone. And you don't mention that before this court. And I think you should have clarified that she was not just only there. She was there alone. And all the time, she's been with her family. Now, you reflect to this court as if this time of 5:30 is the time whereby everything was like mixed up. It was not.
I didn't even get to the question yet, sir. You made your own assumption. I think you want to justify, to clarify something that's playing on your mind. My question, going back to my question, well, just on your point, can you prove that, or is there any statement that can prove that the accused was alone in the flat on the day in question?
She arrived alone.
Is it correct that there could be other people that were already in the flat prior to her arrival? A possibility.
I cannot answer that question. I wasn't inside the flat.
Let's be brave. She had co-accused that assisted her in the alleged murder that were inside the flat prior to arrival. Can you dispute that?
I cannot.
Okay. Thank you. So by you saying that she was alone in the flat is your assumption, correct?
She arrived alone. The statements given under oath are that when she arrived, she was alone, and according to her, she locked the flat and left, and no one has ever gone, and there was only one set of keys. Therefore, if she only had one set of keys, how could the second person be into the house? How would that person could have gotten access to the house?
How do you know the accused only had one set of keys?
She said so in her affidavit.
She could have been lying. You agree?
Under oath.
Because she lied about everything else.
Under oath.
According to you. Okay, let's move on. Now, sir, besides the tenant in flat number 8, getting back to my question, was there any other witness who would have seen Jayden besides the first person being flat number 8?
Yes.
So there were other people who saw the child and just
No.
ignored it?
Your question, you said, is there a person who could have seen? Yes. The person that left at 5:30 could have seen Jayden's body if the body was there. But the person walked out. There was no one.
And there were 10 other tenants who could have walked between 5:30 and 6:25, correct?
But I don't have such information.
Yes. Can we get back to my question, sir? At 6:25, tenant number 8 was the first person we have to assume that saw Jayden's body and brought it to the attention of the guard. Do you agree with that?
I agree.
And we're not fighting over timeline. We were going to work with the evidence that was supplied and you testified to. That the guard saw the applicant leaving at 5:30 a.m. You agree?
That is the statement given by the night shift security guard.
Yes. Who is possibly your main state witness that can place the accused at Swazi Place on that morning, correct? So we have to assume that his statement is the gospel truth and that he saw and recorded everything that occurred that morning. You agree?
Not only him. There are other evidences that can be used
fair
to
enough.
place.
I am saying that the main state witness that can place the accused at Swazi Place on that morning is your guard, Mr. Madunda. You
Yes.
agree?
Yes.
No other witness can testify as to timelines or what time she arrived, what time she left, besides Mr. Madunda, correct?
No.
Okay, we'll leave it for argument. So from the time Mr. Majunda saw the applicant leave, 5:30, and from the time the child was found at 6:25, it was 55 minutes. Do you agree with that?
Yes, I do.
Okay. So after the accused left, you confirm that at 5:30 the Jayden's body was not on the stairs when the tenant walked down the stairs to go to work.
At 5:30.
At 5:30, yes.
Yes, and the applicant was still in her flat.
Sir, we're getting to that. Calm down. At 5:30, the tenant walked down the stairs. There was no body there. So the applicant then left at 5:30.
5:47, according to her.
According to her.
Yes.
So from 5:47 to 6:25, anybody else could have left Jayden's body there. You can't dispute that, correct?
No, I can't.
Thank you. We could have done this 10 minutes ago, sir. Thank you. Now, let's move on. The charge sheet under paragraph 7, have you seen the charge sheet, sir?
No.
I know you didn't draft it. The charge sheet states under paragraph 7, on the 14th of May 2025, the deceased was discovered by a security guard in the passage a few meters outside his residential unit. That's also not correct because we now know that tenant number 8 found Jayden.
Mr. Naidu, the tenant said, let me go back to the tenant of number 8 statement so that you can understand. A8. When I arrived at the gate, I found the security who was on duty talking to the other lady who I don't know her name. I heard them talking about the missing child, and that lady said the child that missing was on the same school transport with his child. I then asked the security what they did about the whole incident, and he said the incident was reported and the police came to premises the previous night and searched only the ground floor of the complex. I then asked him, he did search the whole complex. Okay, I then told him that I saw something. So the confirmation was made by the security. This lady said, I saw something on our floor and I was not sure what was it, and asked him to go and check. I believe the reason why in the charge sheet is written like that, the person that confirmed that what was seen was a person is the security, not this person.
I accept that, sir. Thank you for the clarity. Thank you. Okay. Now, you also supplied a memorandum to the court, correct?
Yes, I did.
In that memorandum, it was members of the public, the accused family, etc., that marched to, was it Florida SAPS or Roodepoort SAPS?
Florida Police Station.
And the contents of the memorandum was that the community activists, they were tired of the crime in the area, correct?
That is true.
They asked for a police station to be either a temporary one or a permanent one to be built in the flare-up area, correct? And they wanted more visible policing.
I can confirm those contents if I go through it. I didn't.
Oh, do you not have a copy of the memorandum, sir? Sorry, I apologize. I thought you were in the docket. Are you in possession of the memorandum, sir?
Yes, I am.
Okay. Now, the memorandum that you have, it is not the community members marching to Florida SAPS in opposition of the applicant's bail, correct?
I think I may have given a wrong document. There is a document in the car, I believe. Handwritten.
But we're not supposed to have sight of the memorandum that you gave us.
No, this is part of it. There is the one that is handwritten is the one that was in particular with Jayden's issue.
Yes, and that issue.
Where is that document?
I can look for it. I don't have it here. I thought it was part of this thing, but it's handwritten.
Is anyone here who can give instruction to go and find it for us whilst we're busy?
Also the SCP-13 from LCRC, or should be they're going out. May I proceed, Your Worship? Now, sir, the memorandum, it is not a memorandum or a document that was supplied in opposition of the applicant's case, correct? That was community members that wanted more visible policing, they wanted a police station built, and they also wanted answers into Jayden-Lee's murder.
Okay, when I asked the same colleague of mine to pass the document, I assumed he passed this together with that one because they were both delivered on the same day.
Yes. At that stage, was the applicant arrested for murder, sir?
No.
So, again, you are trying to mislead or avoid answering the question. What date was that memorandum handed to the station, sir?
I think it was the 17th
Of
May.
Of May. The accused was arrested on the 11th of July.
Yes.
So it will be safe to say that when that memorandum and whatever petition with 1 million signatures was handed to you, the applicant, the memorandum did not have anything to do with the opposition of bail for this applicant. Correct?
But it suggests so.
How can the community march on the 17th of May opposing bail for the accused if she was not arrested?
They were not opposing. They wanted justice for the child.
Yes.
Now that the applicant is before this court, it would be in the interest of state or justice for them to see a person that they have been supporting and she happens to be sitting where she is seated, if they see her outside, because people were crying for the justice. Now, they didn't know at the time who the person responsible for the death of the child was.
I totally agree. Let's leave it there. So,
Are we going to try and sever?
Your Worship?
Because the memorandum, which was marked F, had attachments to it.
Yes, Your Worship, I'm aware of that.
So I want to understand, are we going to sever these parts from the memorandum? Because here,
Your Worship, I believe it's two totally different documents.
so we need to clarify that.
Yes, Your Worship.
This attachment to the memorandum indeed speaks to bail being denied. So maybe we can start by clarifying that. Do you understand?
Yes, Your Worship, there's online a petition, which is the main thing here, the main supporting document on behalf of the community.
Yes, so that is what the things is now getting to. We need to sever or distinguish the memorandum from the actual petition and when this actually came to the fore. I can see here, this is a call to sign a petition to deny bail for Tiffany Meek. At that point, there was already 2,565 verified signatures. But this does not have a date as to when this happened. So
Can I
let's
get to that,
clarify.
Your Worship?
Okay.
Now, sir, that attachment that you have, when was that petition started?
The
The
petition,
online ones.
The online.
I can approach to that one with administrators.
Okay. There no, you handing up a document to court, is there no statement or affidavit under oath attached to that?
No.
So we can't verify
You wanted to consult. I'm also at the same position you were.
No, what I'm saying is you already made that an exhibit of the court. Did you not have an opportunity to ask all of these questions or consult prior to you handing it to court? You just accepted it and supplied it to us.
Yes, I accepted it.
So, how do we know the authenticity of that?
By reading it. And like I said, I can approach one of the administrators, then one can clarify as to when did this started.
You think it was possibly maybe after our court appearance on Wednesday or Tuesday when
No.
the court asked for a petition?
No. Long time ago.
All right. Your Worship, can we afford the witness lobby just for the sake of clarity?
I'm not interested in the authentication of the document. I'm interested as to when this went viral.
My instructions are after the court asked for a petition on Tuesday afternoon, Your Worship.
So let's clarify.
That is.
It should not be difficult.
Yes, Your Worship, the petition started when the community started knowing who the perpetrator is in the matter.
What date was that, sir?
The 11th.
The 11th.
After the 11th. She's still checking time, the exact date, but it started after they had that who was arrested for Jayden-Lee's case.
My instructions are from the applicant's family and friends that approached me that Ms. Solomons and another female stood outside the court and appealed to people to please sign an online petition that was starting on Tuesday this week in opposition of bail. Sorry, Your Worship, forgive me. Tuesday, 22nd. The 22nd of July, that a video was made outside the Roodepoort Magistrate's Court by Ms. Solomon and another female, appealing to the public to please, that they're going to do research during the course of the night. They're going to have an online live petition for people to sign.
It's the same Ms. Solomon.
It's the same Ms. Solomon.
Impeccable reputation.
Exactly. That's the same person that I have the utmost respect for.
Absolutely.
Yes, Your Worship. Now the same Ms. Solomon. The same as Solomon asked the public now to please. They were also offered free transportation, sir, to come to court and protest outside. Because when we left court on Tuesday afternoon, there was about 8 people protesting in opposition of bail. And on Wednesday, there was nobody when we left court. And today, there's probably 50 people outside. Or 100, 1,000. But they only started coming in their numbers when the court asked for this. So you see how the public outcry is influenced by social media activists and TikTok activists. And so if the court didn't ask for a petition, it never existed. It was only created after the court asked for the petition on Tuesday the 22nd.
The court,
do you agree?
The court asked for the petition after I indicated to the court that there is a public outcry. The magistrate then asked whether is there any assertion to what I was saying. Hence, I had to bring this.
And you agree, at the time when you testified under oath, that document never existed. You were talking about the petition and memorandum that was handed on the 17th of May, 2025. And I want to remind you again that you're under oath, sir. You were talking about the memorandum on the 17th of May, 2025, correct?
Yes.
Yes. On the morning of the 23rd of July, that document was supplied to you.
Yes.
So that petition never existed when you gave your evidence on the 22nd of July.
But same people,
Sir, let's stick to the answer and the question. That document never existed on the 22nd of July 2025 when you gave your evidence.
people that are involved in this can attest to what you are saying to me.
You had no knowledge that document existed on the 22nd of July 2025.
I knew that people were having something
Listen to the
against
question again.
this.
You had no knowledge that there was a petition that existed containing signatures when you testified. You only testified of your knowledge of the memorandum that was given on the 17th of May, where members of the community marched to the Florida SAPS.
That is correct. That is correct.
Let's not go any further. That document was created on the night of the 22nd of July and handed to you on the 23rd of July 2025.
As to when was it created, I cannot tell you. As I have answered you earlier, I said it was done after they knew who the suspect was.
That's fine, I accept it. Let's move on. Now, Ms. Solomons, the same Ms. Solomons, took the entire community and went to Florida SAPS asking for answers, etc. Correct? You agree? Or she was part of the community activist?
I don't know who led the march, but
Correct.
I know there was a march. As to who was involved, I cannot tell you.
Fair enough. Now, all of them, even Ms. Solomons, from the date of Jayden's death, or the time his body was found, they stood by the accused. They supported her family, made videos, etc., in support of finding the killer and justice. You agree? Or
Okay.
you aware of that?
I think so.
Okay. Now, those same community members, whether it's 4,000, 10,000, stood by the accused and her family and wanted answers and wanted somebody to be arrested. You agree?
I do.
Now, the police did an excellent job in arresting the applicant. Now, the same community have turned against her. Correct?
Yes.
Now, since Wednesday, since your testimony and the cross-examination, 2 private investigation companies have approached the applicant's family and have volunteered their services free of charge to dig deeper and find answers in favor of the applicant. You're not aware of that?
No, I'm not aware of that.
Now, I'll put it to you. If that private investigation company is correct and they want to stand by the applicant and they find another killer or another suspect, my apologies, Your Worship, wrong word, another suspect, and they can link him to Jayden's murder, and the state is now forced to withdraw the charges against the applicant. Your Worship, I didn't even get, I don't know.
Where are you going with this?
Your Worship, I'll get to it. Sorry, Mr. Duma, I'll get to it quickly, I promise. Now, sir, I'm just trying to show you how public opinion sways. If that private investigation company can bring another suspect before the court and the state is forced to withdraw the charges against the applicant, that same community members will stand by the applicant and her family and oppose that suspect's bail and say, now justice is done. The real
We have to hide. That has to be nipped in the partnership. That's just speculation. And
The argument to be made is that public opinion is fickle.
that's it.
Thank you, Your
Let's
Worship.
proceed.
I'll proceed. Thank you so much, Your Worship. Now, my instructions in respect of count
So
number.
before we go off this topic, there's no handwritten petition. I heard the words handwritten.
Your Worship,
I said I heard the words handwritten.
I mean,
What happened to that handwritten document? Big release
I thought he had gone, Worship, to fetch it.
I thought so too.
Thank you. May I proceed?
Absolutely.
Thank you. Now, sir, in respect of count 3, I think, criminal injuria, the applicant will state that at no stage was Mr. Kumalo's property searched on the night in question. In fact, the police only questioned him as to what time he dropped Jayden off, and that was the end of the conversation. They left.
From what was said by Mr. Kumalo is that her place was searched.
Now, the applicant will also testify that when the police came back, it was around 9:30 that evening on the 13th of July. The police had commented that it was too cold for them to conduct a search. It was not yet 24 hours for them to go searching for Jayden. And neither did they request to search the applicant's flat on the night in question. Are you in a position to dispute that?
I cannot say anything to that. I wasn't there.
Thank you. Now, of all of the exhibits that were recovered, was any item of Jayden's school clothing recovered with blood on it? And descriptions of his clothing on the day in question. Was any item whatsoever recovered as an exhibit and sealed in an exhibit bag containing blood?
On those that you've mentioned,
Yes.
no.
So no item of school clothing whatsoever has ever been recovered in this matter.
They were photographed, but not sealed as you asking.
Yeah. Did the photographer make a statement?
Yes.
How many times did the photographer come to Swazi Place? In totality for this matter, or this investigation?
He came on the 14th and on the 16th.
and 16th of May 2025.
Yes.
Are there photographs depicting Jayden's underwear and that so-called towel containing blood that was never seized by the police in the tub on the 14th of May.
Yes.
Is that photograph available?
Yes, it is available.
We should review this first.
Yes, is that inside?
Please can the photograph be handed over, sir? Just to clarify, sir, is the towel red or maroon in color, or is that blood on the towel?
It's maroon.
It's maroon. Thank you, sir. Can I have the report of the witness, Your Worship? Thank you, Your Worship. May I leave to hand save up?
Thank you. Exhibit N1 and 2.
As copies. Now, sir, you confirm that towel was never seized.
Yes.
If I handed that picture back to you, can you point out the bloodstains on the picture?
Blood stains.
Yes, you said the towel contained blood. Can you point the blood on the picture?
I never said it contains blood. I said there were traces to the drain of the bathtub.
Your Worship, let the picture be handed back to the witness, please.
There's traces of blood
Yes,
going to the
going to the drain.
drain.
Can you just mark with an X where's the traces of blood on that picture?
Now here I don't see, but when I saw the bathtub, I saw what I'm talking about.
That is an exhibit that you intend using as a trial, taken by a professional photographer employed by the SAPS, and there's no blood stains on it.
I think that doesn't have weight because that blood was never taken or the towel was never taken. Therefore, it cannot assist and it cannot assist us with anything.
Now, it can't assist you, sir, but it could have assisted the court. How do you make the decision what is going to help the court or what is going to be necessary and not necessary? Is it your decision to do that, or do you have to capture all of the evidence?
I have answered this question surrounding the towel issue, that it never crossed my mind that I should seize this. So I have no further info providing around the towel issue.
Okay. So if I had to put it to you that there was no blood in the tub, there was no blood contained in the towel, you can't even dispute it because you don't have the exhibit anymore.
I can't.
Okay, thank you. If I had to put it to you that the underwear that was found in the tub was from 5 days before, you can't dispute that.
No, I cannot.
Oh, it was from 5 days.
Days before the witness. Thank you. Now, it's also my instructions that when the dog and the dog handler arrived and went up to a flat in the same building, I'm just going to call it flat number 38 for argument's sake, that I'm sorry, I don't have the exact flat number, but it's known that at some stage after the police because the police initially refused to open the flat because they did not have a search warrant, and neither did they have the keys. But later that same day, the flat was opened by either the landlord or the security guard who had keys for that flat. Are you aware of that?
No, I'm not. From what I heard from the landlord, the flat only had the keys that were issued to the applicant. Even to date,
No, sir.
the landlord.
We're not talking about Unit 13. We're talking about the flat that the dog got sent to and went on the last floor of the building.
I think the dog handler is the only person to attest to that.
Okay, we'll get to that. Now, it is my instructions that later that day, the flat was opened.
Which one?
The flat on the top floor, where the dog followed the scent to. And inside that flat, there was a pillow containing blood. Are you aware of that?
No, I'm not aware of that.
There was also what looked like semen that was present. Are you aware of that?
No, I'm not aware of that.
And it is my instructions by the applicant that all of this was relayed to her by, once again, our trustworthy and honorable Ms. Solomons.
Just repeat that for the record.
And that the applicant was informed of this by Ms. Solomons, Your Worship, who witnessed or saw this.
I don't know anything about what you are saying.
With all due respect to you, sir, and all of the members at Florida SAPS, it seemed that in the investigation of this matter, the community and the community activists have played a more important role in trying to ascertain answers, go into these flats and view the exhibits, etc. And the police refused to assist the applicant or her family.
I have never seen any activist member or any member of the community being part of our investigation. The only way I saw them supporting is by this petition, but to be part of the investigation, we've been investigating this case as police officers, not the community members.
So for the record, what you are saying in essence is that the Honourable Ms. Solomon never approached the police to say or to give evidence or information of semen that was found in the unit.
No, I don't know nothing about that one, Your
No
Worship.
statement to that effect.
No, Your Worship.
Here I put it to you, Ms. Solomon has over 100,000 followers. All of them have viewed videos confirming what I'm telling you. And
What?
I'm not going to mislead you, sir. I'm an officer of the court.
What is in her information? I cannot tell you about how many followers. I'm not a social media person, me myself. So I cannot tell you about how many followers and why are they following her. So that one, I cannot say anything to what happens between her and whoever that is following her.
They follow her because they want the truth. We all want the truth. We want justice for Tiffany. We want justice for Jayden, sir.
That is
what
very,
I'm saying is
that is very important.
Is that there are a sequence of events that followed the death of Jayden, and the police failed in their duties to follow up with all of these. A dog, Jayden's pillow was supplied to the dog handler. The scent of the pillow led to a flat on the 3rd floor. The police refused to go and enter that flat. And on the very same day, other members of the community gained access to that flat, that the police, even if they had reasonable suspicion they could have broke down the door, refused to do their job.
As I said earlier, this information you are giving will be tested with the right people, because me and you, we're using information that may be from some other people, but the dog handler was there and his
You agree?
People
with
have-
with more than 15 officers present, maybe not.
Yeah.
But that's
That's another argument.
Let's proceed.
Thank you, Asha. Now, I'll put it to you that the pillow that you speak of, my instruction of the pillow that contained blood was seen at the flat where the police dog got the scent to.
Earlier, I said people who can give you answers are the people that were at the scene of crime. And we have statement of Mr. Mloy who says nothing about what you are saying. And we have only one pillow, and I don't know about other pillow. That would be a second pillow maybe, if there is another pillow. Because the pillow I know is that one that was found from flat 13, not from anywhere else.
Thank you. Were there any strangulation marks on Jayden's body?
I can go to affidavit and statements from people who had a chance to look at Jayden's
No, are there any
body.
pictures depicting strangulation? Because my instructions are that there were hand marks on Jayden's neck that he may have been strangled, seen by the applicant and other members even.
This is now the time the body was found.
Yes, Your Worship, and at the time at the hospital, when the child was taken to Discovery Clinic or hospital.
You observe strangulation marks on the neck of the child.
Yes, Your Worship. Is there anything mentioned of that, or any pictures depicting that?
Around his neck.
Yes, sir.
I can give it to you, then you can have a look.
No, is not. Are there no pictures? Well,
There are pictures, but for me to describe what I'm looking at, maybe it would look differently to you.
Okay, maybe it will assist.
Before you hand over the pictures, give it back to the If you are going to have insight to the pictures, you are effectively saying that you. If you have a look at your post-mortem,
Yes, Your Worship.
what does the post-mortem say?
Your Worship, there's nothing.
It specifically deals with the aspect of head and neck.
Yes, Your Worship.
Okay.
There's not one, there's only 2 points there, Your Worship.
So the post-mortem is silent
Yes, Your Worship.
as to
That's what I was hoping this photographs.
strangulation marks.
That's what I was hoping this photographs that could show. If it's there, because this was the point of my question, if there's any photograph depicting that. Because it was seen by the applicant and a family. So what I'm saying is, why was it not captured in a photograph?
One of 2 reasons. It either was or it was not.
That's the point, Your Worship. I'll move on, Your Worship. Sarifiko, these block of flats, are they close by the neighbors, like Unit 13 or Unit 14, Unit 12? Are they in close proximity to each other?
Yes,
And how many bedrooms are the applicant flats?
2 bedroom.
2 bedrooms. Now, had the child been assaulted as severely as the injuries depict, Did anybody depose to an affidavit that they heard screaming coming from inside the flat?
No,
The child cried on the day in question?
no,
Or there's a history of where the child was being abused prior to that?
at home or at school.
At home. We're talking about Unit 13.
No,
No affidavits confirming that. So, had the child been assaulted so severely, I know it's an assumption as well, surely with the close proximity of the flats, people could have heard the child crying or screaming for help.
to answer that question, if you push a person once against the wall and the person passes, no one would hear any voice, because you'll never hear a voice if a person dies from that pushing.
But there were other injuries.
Yes,
to the
you
lip,
push, you
to
push
the
a person,
head.
you push a person against the wall and the person comes and hit with the face. If that is the case and the person passes from there, you'll never hear a voice of that
But
person.
you cannot state with certainty that that's what happened to Jayden, correct?
No, I'm not saying, I'm answering
Yeah,
your
no,
question.
I know, that's what I'm saying. I'm saying, yeah, if child, if there was a history of assault, there's a possibility the neighbors could have heard.
Yes,
Yes,
hence I'm
because
giving,
the flats are close by to each other.
yes, hence I'm giving you this example.
Yes.
If you push a person hard against the wall and the person comes back, fall with his face and passes on or dies there and there, no one will hear a voice from that person.
Was there any blood found on any of the walls?
I'm still waiting for UV light people to tell if they did found blood.
Okay. Let's assume the child wasn't pushed against the wall. Has the murder weapon been found?
No, I never said the child was pushed. I was just
No, I
making
know,
an
I'm
example.
just saying, I said, let's assume the child was not pushed against the wall and the cause of death was not blunt cross trauma to the
Head.
head. Let's assume there was a murder weapon used. Has a murder weapon been recovered?
No.
Well, I think it's a prudent question. Did you manage to secure the OB entry book?
Yes.
Is it present?
Yes.
May we have sight of same
Yes.
version? Or just bear with me, Asha.
Whilst I'm bearing with you, maybe it's pertinent to place on record that when you do have a look at the post-mortem, there is the heading that says neck structures. It pertains to the neck dissection that was performed, the hyoid bone, the laryngeal cartridges, there are no bone or cartridge fractures. The larynx was intact with normal structure. There was no structural foreign material present in the larynx. The thyroid gland was intact and congested with no visible pathology. The blood vessels were intact with no visible pathology. And the soft tissue of the neck, there was no visible injuries or hemorrhages. That's just for the record.
And what is this?
Your Worship,
Yes.
there is a gentleman, the owner of the security company, who can assist him with questions that he had with regards to the OB.
That's fine. How does the OB look? Can I just see it? Just hold it up. It's an actual book. Okay.
Worship, I confirm receipt of the OB book. It starts on the 6th of May 2025. Worship, I'm not sure if the witness is in a position to differentiate the day shift and night shift guard's handwriting. To the best of my untrained eye, Your Worship, it would seem like one person wrote the entire book from the 6th of May leading up to the 13th of May, Your Worship. Just we can get some clarity, Your Worship. Sergeant Biko, are these two guards still employed at Swazi Place?
No.
No. Are they still employed by the security company?
I can approach the
Please do,
employer.
sir. Yes, sir.
No longer in the employ that were they at the time of the incident. However, they are still in his database.
Sir, are the both guards still employed by the same security firm? Yes or no?
I can confirm. I can confirm. That is the answer he gave me. He said he's no longer with them, but he can access them. They are
Answer
still
is
in
no.
his.
They are no
Yes.
longer employed by the same security company.
I
They are
think,
not on active duty at any site currently.
to be precise, I think he's the one to tell.
We're not calling him to justify, so you are the median for that. When were these guards relieved of their duties?
I must go and approach again.
Please do. It's of vital importance because the next question is going to determine that. Your Worship, I don't think the 15 policemen are keeping the crowd quiet now.
Okay. Assistant, would you have a moment to consult? Because now we're having consultation amongst the public. Sergeant, do you want a few minutes to confer and consult with this person? We have all the information.
Which people are answering in the gallery. It's really disturbing that people see in the gallery are answering yes for the witness. I'm not sure if the court needs to clear the gallery because I don't know if they want to assist him.
As requested, can you just have respect for the proceedings that is continuing? I was asking, did you get the information?
Yes, Your Worship.
Okay.
Can we proceed?
When were they relieved from the duty?
A week after the incident.
So that will be around the 21st of May, correct?
Is that a week after?
Week after. Jayden's body was found on the 14th of May. A week later was the 21st of May. 7 days. Correct.
A week
later.
A week after.
A week after. 14th of May to the 21st of May is a week after. You agree?
Yes, I do.
You should have leave to hand the book back to the witness.
Thank you.
Can you please differentiate? Oh, I'm not sure if you're going to have to approach the witness, the security company again. Which is the day shift guard's handwriting and which is the night shift guard's handwriting?
I must tell you.
Just a moment.
Your Worship.
I think this is the question. My colleague answered the question before he asked.
Are you in a position to tell us which is the day shift guard and which is the night shift guard's writing, sir?
Writing, I said I'm not a handwriting expert,
Did
therefore
you not
I
check
cannot
with
tell you.
With your witness, when you received the book, did you not ask him to point out, this is Mr. Magunda's handwriting, he was the, on the day in question, he was the night shift guard?
No, I never asked that.
Why I'm asking you that is because if the guards were let off on the 21st of May, the exact same author who wrote on the 13th, the 14th, as far as the 26th was still writing in the book. It's the same handwriting from the 6th of May to the 26th of May. Have a look at the book and challenge me on that.
I think these people, they
You
will
know
have
these people, sir.
the
It is a night shift guard and a day shift guard. If I am on duty as a night shift guard, I am the only author who will be writing that OV book. But when I go off duty, the day shift guard or the night shift guard come on duty and then he'll write. We will have two separate handwritings. And if my boss dismissed me on the 21st of May, how am I still writing on the 26th of May? Peruse the book from the 6th of
I'm
May.
looking at this, but I cannot tell whose writing is this. I think when those people are called to court, a person can say, this is my handwriting, this is my handwriting. Myself, I cannot tell you whose writing is this. What if their writings are identical?
Two individuals, the handwriting is identical.
I'm asking you, what if?
Peruse the book, sir.
I am looking at the book.
Read from the 6th of May to the 26th of May. It's the same handwriting continuously.
But my colleague opened up that very answer that the witnesses gave. He is the one that elicited that very answer that the witnesses is giving. Unless my colleague can say with certainty that, from a point of view of expertise, it's exactly this. The font, and whatnot, the dotting of the I's, the crossing of the T's, and so on are the same. Then indeed that is so. But my colleague is the one that elicited that very answer. And Worship, we are requesting that answer that the witness has just given be accepted. What if two people write the same?
Okay.
Leave it for argument.
I'll leave argument. Sir, look at the entries on the 13th and 14th of May. Just look at the handwriting, the entries.
Yes, I'm looking at
You
it.
got that?
Mm.
Now that is the two witnesses that you have already received statements from under oath, affidavits, confirmed.
That is correct.
Right. That is, we can assume that is the day shift and the night. We're calling them the day shift and the night shift guard, correct? Those same two individuals have now been relieved of their duties. They're no longer employed by the security company. We're going to use a timeline and say that they were relieved of their duties around the 21st of May. You agree?
Yes.
Now, I put it to you that on the 26th of May, one of those two individuals were still writing in the OV book.
I cannot tell exact date. A week later after the incident. Therefore now you are specific with dates as if I received an exact date. I didn't receive an exact date other than a week later.
The reason I'm emphasizing this is because the applicant is in a state that OV group where she wrote down with her own handwriting, she wrote on a name, a telephone number, what flat unit she belongs to, is not the book that you have in your possession. That book has been reconstructed from the 6th of May to the 26th of May.
If you're saying that, I will take you back to your affidavit, to your client's affidavit. Can I please have time to check?
What is it you want to get to?
Whereby she doesn't mention that what you are saying she wanted to do, or she wrote in the OB. On your affidavit, there is nothing saying that something was made on the OB.
Fair enough. Fair enough. What I'm saying is that the applicant will state that the OB book that you have in your possession now is not the book that was there on the 13th, where she wrote her name and number. The pages that have been supplied to us in this bundle is not the same book and not the same recollection. That entire book has been reconstructed on the 6th of May, including the 13th and 14th of May, with the same author's handwriting. That is what I'm putting to you.
And unfortunately, Mr. Naidu, when it was reconstructed, I wasn't there. Therefore, I cannot say anything to that.
Totally accept that, sir. Thank you for that answer.
Thank you. We'll give you the book.
Worship, I seem to call it to one. I'm not sure how
It's
if we get. Sorry, Worship?
It's just to one of them.
I was hoping we could have the SAB 13 because I'm almost at the end of my cross examination. So. May I continue, Your Worship?
Bill evidence C1.
Yes, bro. So, you stated that for the 14th of May, the day that Jayden was found, there were photographs taken. How many photographs in total were taken?
$35.
95. Is the date reflected on those photographs?
No.
The date?
This is one of the questions I posed with the request that I had earlier, that
Yes.
the photos that was handed in to the marked as exhibits to be accompanied by a 212.
Correct.
You managed to get the 212?
So, that is correct.
Can we have the 212?
Is it there? Is it? Maybe if you have copies.
Can we have the
Yes.
Can I have 3 sets of copies of the 212?
So can I just continue and you can get back to it? Thank you, Your Worship. Now, sir, you said there was 35 photographs taken on the 14th of May, correct? Is it equal? Sorry, sir.
Yes. Yes.
And there were no photographs whatsoever taken on the 16th of May.
He said he videoed. He made a video.
You also stated that from the 14th, on the 14th and 15th of May, prior to your I'm not sure if you stated that, but sorry, it was the applicant's affidavit, that on the 14th and 15th, that there were numerous people going in and out of the flat.
Myself.
Not you, the applicant's affidavit. Her family members, members of the community activists were in and out of flat. In fact, on the 15th of May, there was like a memorial or something held in memory of Jayden at Swazi Place on the 15th of May. Are you aware of that?
I wasn't there.
No, I said, are you aware of that? I asked if you attended.
No, I'm not.
You were not aware?
I'm not aware.
So there was this massive prayer meeting held in memory of, on the 15th of May. Nobody, not the accused, not the family members, none of the community members, saw the school bag that was presented to the court.
Were they inside unit?
Yes, they 13? Were inside unit 13, they were out on in the parking. The accused and the family were allowed access. You didn't seal off the unit, correct?
Sorry?
Was unit 13 locked and sealed and nobody was allowed access to
I
it?
believe after the scene was purified, the keys were handed to the right person. And
who's the right person?
I don't know.
Oh.
I'm told Simon, the sister to the applicant, is the one that opened the door for police officers to do their work. I assume after the scene was processed, the keys were handed back. Then whoever that was in possession of the keys from the family side should tell who opened and...
That's fine. Let's assume it was Simon. Let's assume it was the applicant. For 2 days, the applicant, a family, and other members of society had the keys to go in and out of unit 13 on the 14th and 15th prior to your arrival on the 16th, correct?
I don't know. I wasn't there.
I said, logic dictates, you gave them back the keys.
Oh.
Somebody gave them back the keys. They had access to that flat on the 14th and 15th of May. Because the keys were voluntarily given back to them. The police assumed our job is done yet. Here's the keys, take it back. You agree?
But I doubt if police officers have ever handled the keys other than asking a family member to open for them. So whoever that was in possession of the...
You're preempting the question. I'm not asking. I'm saying that the keys, after you all secured the police, the scene of the crime, you all took forensics, photographs, etc. Recovered, even let's assume you all recovered the pillow, which is denied by the defense. The keys were voluntarily given back to the family and said, there's the flat keys. We have now recovered whatever exhibits, taken whatever DNA, you are free to go back into your flat.
You are painting the wrong picture, Mr. Naidu.
What picture am I painting, sir? My question to you is, was the keys voluntarily given back to a family member on the 14th of May 2025?
By who?
By anyone of the SAPS, whoever.
No, keys have been with the family. They have never been to the hands of SAPS members.
Okay.
The family opened for SAPS members to do their work.
Yes. Sir, what I'm saying is that, was there any order given to the applicant or family that nobody is allowed into flat 13 after you left the scene?
I wasn't there when police officers parted ways with the family on the...
Let me just get straight to the point, sir.
Yes, this was
From the 14th to the 16th, the applicant, a family, members of the public, had entry in and out of flat. If the accused knew there's a possibility she's going to get charged for murder, she had access to that school bag and she could have disposed of it. Do you agree with that?
I am not sure about that one.
So you all saw the bag there on the 14th.
Yes.
You all photographed the bag, left it there in full view of the alleged murderer, in open view. It was lying outside of a cupboard. And decide 2 days later, oh, we need the exhibit. And then you go back on the 16th and the exhibit is still lying in the same place, sir. Is that your evidence?
I think people that were there can tell if she has ever been to the flat during this time that you're talking about, because it's possible that after the day of the incident, she has never been to that flat. Therefore, she couldn't have an access to the
You cannot
flat.
state that with certainty, sir.
But
Sorry.
there's people that have been at the gate. They can tell if she has ever been back to that place.
Do you
or
have an
not.
affidavit confirming that? At this point of the proceedings?
If it needs be, I
No.
can have it.
Do you have an affidavit? in
Not
your
now.
office, sir? Not now, okay. So we have to assume the accused, or even accomplices. She could have instructed her brother to say, I killed Jayden. I left the bag in there. It's a vital evidence. Please remove it and dispose of it. You agree she had access to the bag on the 14th and 15th prior to you seizing it.
Do you think you can think of everything to shift if you have made a mistake?
I am not the one in the box, so you don't get to ask me questions.
All right, I'm so sorry about this.
Right. Be there as it may, sir. It all goes back to the applicant's affidavit that the evidence was never there on the 14th and 15th. She stands by that the evidence was planted from the 14th to the 16th. The evidence was planted there. There was no school bag in that flat from the 14th to the 16th. The police then requested access. Somebody could have tipped them off that you had forgot the school bag, but there's a school bag in there. And you went back into the premises on the 16th. And that's the only time the bag was seen or heard of for the first time ever.
If this bag was framed, that means it was framed before the scene was photographed. Because photos that were taken on the 14th, they depict the photo of the school bag.
Undated photographs, sir.
I haven't seen them dated since I joined SAPS, so I think that could have been fixed somewhere else.
Where's the 212 for that then?
Yours may I also read just
Yes? This 212 I have in my hand now. It's 200. The 14th.
Yes, I should. And then there's one for this. On the 14th, there's one with 2 times the ship, and then the 16th as well. That's what it should be.
You have 3 pages.
I have 1, 2, 3, 4 each.
I have 3 pages. Just
And
count
the
it.
ship. May I just give the court my?
Just hold on.
Okay.
So I have on the 14th, at 11,
Yes, and that's 1 page, Your Worship.
and on the 14th
Yes.
at 12,
And that's 1. And then it is.
and then the 16th, only 1 page, 1 time.
Yes, that's a 14th, and then 16th. It's supposed to have 2 pages. The other one is information, and then the last page is the commissioner's page. I can give you a copy now. The one with the copy, yes. Sorry.
Is this how much one to give me now? For the commissioner's page?
Yes, so there should be 4 pages.
Yes.
Okay, thank you, Your Worship.
Now do you have it?
Yes,
That's
but
2 times the pictures for the 14th, 1 at noon and 1 at 12.
yes, Your Worship. I've got 4 pages in total.
Yes, I agree.
Yes, Your Worship.
The same mindset and
Your Worship?
are the same person.
Yes.
Yes, Your Worship.
And then on the 16th, 5 past 8.
Sorry.
That's the evening.
Your Worship, I note that the events for the 16th is dated the 19th of May, and for the 14th, it's signed and commissioned for the 26th of May. Your Worship, this evidence is only requested on Monday, and the witness said that he was not in possession of it. I'm not sure.
But it was never said the documents or not. It simply said it did not have access to them. So I'm not sure what aspersions my colleague is trying to cast.
No, you see, it was not contained in the docket.
Yes,
That was available.
Yes.
Hence we managed to get hold of it.
Thanks for that clarity, Your Worship. Your Worship, I don't see the key to the photographs attached. If you look at paragraph 4 of the statement of the 14th of May at 11 o'clock, it says a key to the photos are attached. We have not been supplied with that, Your Worship. may I continue? Board.
The time is
This
now
one
1 o'clock,
o'clock.
we've adjourned for lunch. Can we get this 212 sorted out in the lunch adjournment?
There's a copy of this.
I will leave my copies here so you can fix it. Put adjourns for lunch. Just under oath. Thank you.
All right.
Yeah, buona.
I think it's all I'm joking, I'm reaching. Tell me about the book.
Hey, let's check this thing out, man. Let's go.
memorandum was marked F, will mark this F1.
As God uses.
Let's just see.
Thank you, Worship. Now, Sergeant Deco, the document that you handed out, there's not a petition containing signatures, the handwritten document that was just handed up to the court. It's not a document containing signatures of people in opposition or bail of the accused, correct?
Yes.
It's simply another memorandum that was handwritten and not typed out.
It was handed into Florida SAPS by the community people that were behind the accused before this court. So they were in support of her, therefore they needed justice for Jayden-Lee.
Yes, sir. What I'm saying is the document, it is not a petition, it is a memorandum, but it's just simply handwritten. A petition is where there's attached signatures of members of the community attached as a petition to say, we stand by the applicant, we are here in support of her, we want answers, here's our name, address, contact details and signatures. That is a petition.
It was accepted as a petition as it was rendered as such by the community members.
You agree there's no signatures whatsoever?
Yes, I
by
do.
community members?
Yes, I do.
Okay, thank you. Now, prior to the lunch interval, we were given two documents, which is the statement from Warrant Officer Mayisela and the key to plan. Now, I noticed on the 16th of May 2025, the warrant officer, I'm not sure if you were also present on that day, went to Unit 30 in Swazi's place at 8:05 that night, 8:05 p.m.
Yes.
Is there any reason why that evidence could not be recovered during normal office hours? There was a specific reason you had to go at 8 p.m. that night?
Services of SAPS are 24 hours service, therefore that was the time we were able to go to the address.
Okay,
It could have been we're busy with other work.
no problem. Who allowed you access to the premises on that night?
Is one of the family members.
The accused was not present, the applicant was not present.
No.
Thank you. Now, can you tell us how far the investigations in this matter?
I cannot give you an exact time, but the investigation is almost finished.
Almost finished.
Yes.
Can you tell us what's outstanding?
Sorry?
What is still outstanding?
There's a report from UV light people. There's a report for the sheet I mentioned earlier.
The bed sheet.
Yes. There's some footage that must I really?
No, just to the way.
Okay. There is an investigation outstanding,
Okay.
but to point you to everything that is outstanding, I don't think it would be.
The reason I'm asking is because in your evidence in chief, you stated that you had fear and concerns of the applicant interfering with your witnesses, your state witnesses.
That is true.
How many state witnesses' statements are yet to be obtained?
Plus minus 5.
Plus minus 5.
Mm.
Now, the accused, as of today, has been in custody for 14 days. Is there any reason why these statements could not be obtained in the past 14 days?
I've been busy with other work that is here.
Yes. And you also have colleagues who assist you in taking down statements, correct?
Yes.
Were your colleagues not available to assist you? It's been 14 days, 2 weeks.
They've been assisting me.
So there was nobody available whatsoever, even after court hours, to take down these 5 witnesses' statements, to alleviate any concerns that you may have that the applicant may interfere with her once she is granted bail.
The statements that are outstanding can be obtained at any given time. The reason why they are not yet taken is because there was no time to take them. other work that was done. It's not like we had a day whereby we said, I have never rested since I received this case, so it's not like we left them intentionally.
You had 2 months prior to the arrest of the accused. Why were these statements not taken in that 2 months?
We were busy with other investigations.
So 5 statements could not be recorded just so that you know there is no chance of this applicant going and interfering with your state witnesses, threatening them, intimidating them not to depose to an affidavit in almost 2.5 months.
I don't understand what you are saying. You mean the applicant can only interfere with witnesses only if their statements are
sir.
not taken?
What I'm saying is that one of your opposition to bail is that if the applicant is granted bail, there is a possibility or a likelihood that she will threaten and intimidate the witnesses who are yet to give their statements to you. Correct?
That is correct.
It's only 5 witnesses. You had 2.5 months to secure these affidavits, and yet nothing has been done. If you were so concerned about the safety of your witnesses or the applicant interfering with her, why was these statements not obtained prior to her arrest?
I have already answered.
What this is saying is that the fact that the witness makes a statement does not include anyone from interfering with that witness story.
Thank you.
The witness may very well come on the next day and recant the statement, for example.
I understand. Now, sir, for all of the witnesses that have already deposed to affidavits, and which some identities are now known to us and some are not, you agree that there are provisions in the Criminal Procedure Act that if any of those witnesses come forward and make an affidavit that they have been threatened or they have been interfered with by the applicant, you can bring an application to this court to have a bail cancelled or revoked.
Yes.
That is available to you, an option available.
Yes.
Has there been any indication or any statements in the docket up until this stage to suggest that the applicant has interfered or threatened any of your witnesses?
Yes, not an affidavit given, but yesterday there's people that came to say they are very worried about what they are seeing. One of their colleagues is not feeling well about what he saw here. She's not feeling safe, but she didn't come by herself. She sent people.
Did you get the question?
Yes.
Is there any affidavit or evidence in the docket to suggest that the applicant, Miss Tiffany Meek, has threatened or intimidated any of your witnesses to date?
Not yet, but
Not
there is.
yet, sir.
Yes.
So you're anticipating that she...
There are suggestions.
that she will do that?
There are suggestions made to me.
The answer is no, sir. The correct answer would be no.
I don't understand what you're saying. Just back to that, be a bit more clear as to what you're saying.
Your Worship, to his question as to whether is there any person that has came forward to say he or she amongst the witnesses have been threatened or anything that has made someone to have a fear. What I was telling him is that yes, there are suggestions, even though there is no affidavit made. There are people that came to me yesterday to say one of their colleagues is not feeling safe with what he's seeing. He feels like his address has been compromised since he saw that the information of her statement has been handed over to people that may come for her. She's not feeling safe, but she didn't come by herself. She sent her colleagues.
Yeah, proceed, Your Worship.
Please.
And once again, there's nothing under oath to confirm that?
Yes.
It's we have to assume that what you're telling us is the truth.
Yes.
Now, you'll agree that the investigations, apart from the 5 statements, the forensics, which could take the next 3 to 6 months, the UV, it takes quite some time for these investigations to be finalized before the matter is trial ready.
Yes, it does take time.
Correct. Generally, for the UV lights, how long does it take?
I have never waited for this report, but I will follow up with them to find out how long will it take.
No stress. Thank you, sir. Now, when the accused applicant was arrested on the 11th of July 2025, there were reporters from the various news channels stationed outside the Roodepoort police station before she could enter the cells. Now, one of the police officers, I think it's Major General Sakana, was interviewed by, I think it's SABC News. I stand to be corrected, but this is what I've gathered. And he stated on national television, we investigate in order to ensure that the right suspect is arrested. We don't arrest and then investigate after. And in this case, that is what was done. We make sure that all the things that need to be done as part of investigations are done properly and thoroughly. Have you seen that interview?
No.
It's evident that that statement is incorrect because all of the investigations are not incomplete at this stage.
To arrest the suspect, we had enough information. We have enough evidence to arrest the suspect. The outstanding investigation doesn't mean we had an incomplete investigation in arresting the suspect.
But yet there could still be outstanding suspects, correct?
Not one I know of.
Why was blood samples and swabs taken from other individuals?
Those were for eliminating people that couldn't be part of the Jayden's killers.
Yeah, so there were possible other suspects except the accused.
Not necessarily they were possible, but it was to eliminate them from being part of people that killed Jayden.
And there's a possibility that there's still accomplices out there who are yet to be arrested.
I'm not sure. I don't know nothing about that one.
But there's a possibility.
From who?
The applicant could have worked in common purpose with other people.
No, I don't have that information.
Now, just to finalize, to summarize, or end my cross-examination, if I take you back to the video of Ms. Solomon, where she stated that Jayden was initially found on the ground floor, then his body was carried up 2 flights of stairs to the 2nd floor. Now, if we do the reverse, the applicant would have had to come out of unit number 13, carry Jayden, who's, from the pictures you'll see, quite a heavy 11-year-old child, down 2 flights of stairs, leave his body, either go back up or exit Swazi Place without anybody seeing her whatsoever. Correct?
What do you want?
If we have to go on the assumption that the body was found where we put it to you, that Jayden was found on the ground floor and the security guard carried him up 2 flights of stairs. Now the reverse of that is that if the applicant carried out this act, he would have to carry him from flat 13 down 2 flights of stairs that morning. He'll place his body on the ground floor and then make her escape.
You are saying to the witness it's not possible. Is that what you're saying?
Yes, Your Worship. Without being seen by the other tenants.
What do you say to that? Is it possible?
Your Worship, I think this is just a misleading statement. Because the information I have has got nothing to do with what he's saying. The statements have never talked of the child being found on the down staircase. It has been on the same floor where the child lived.
Somebody told Ms. Solomon and the applicant otherwise. That's what my instructions are.
I think
Jayden was found on the ground floor. The security guard carried him up 2 flights of stairs and placed him 2 meters away from the entrance.
I did my investigation. It's my first time hearing about this in this court, that the child was found somewhere else. Since I've done my investigation, the child was found behind the staircase to the stairs, and the security moved him to the other side. Never in any other floor the child was found.
No, sir. I accept that. If need be, we'll make that video footage available for you. I'm sure 100,000 other people already seen it. Now, one of the other concerns you had was that there was a lot of public outcry, the fear or concern of the applicant's safety. You remember that?
Yes.
And that it's a very serious offense, and that the public outcry far outweighs her right to bail. You agree?
Yes, I do agree, and I believe one of the attachments to those things you called memorandum,
Yes.
the online one, it talks of the numbers of those people I was referring to.
Yeah. It's an online application, 4,000 people. Online means they could be in another country.
And another,
attaching their signature online.
and another province.
Because they're just interested in the matter, you understand? Social media online means World Wide Web. It's all over. Somebody could be sitting in America and signing that petition. Doesn't mean the applicant is going to be released on bail and interfere with that person. You agree?
In Durban, you can find those people.
We're not even talking about Durban. The accused are the fixed address within the squad. But be that as it may, your other concern was that there was a public outcry, the seriousness of the offense, etc. And then I questioned you that you've been a detective for 17 years. You've handled so many matters of serious nature where people are still granted bail. They respect the bail system. They come back to court and stand trial because they believe they are innocent, correct? And you said that you don't know. Maybe your colleagues would have investigated this matter, but you're unsure of it. Correct? That the dockets that you carry, you're not sure where other applicants for serious offences were granted bail.
In situations like this,
Yes.
yes.
Okay. Your Worship, with the leave of the court, may I have leave to hand up an article? I've made copies for Your Worship and my colleague. Copy can be added to the witness, please. So, you want that? You too? Okay. I'll give you one. Now, sir.
Before you continue, the 212 statement pertaining to the date of 14th of May is marked N.
That's good, please.
212 statement pertaining to the 16th of May is marked O. Proceed.
Thank you, Worship. Now, Sergeant Diko, I've given you an article that was published in the IOL. The author is Siyabonga Sitole. It was published 2 weeks ago. I printed it on Wednesday night, so 2 weeks, 2 days. Now, you're familiar with this matter. The accused in the matter was Umdaduzi Umnisi. Are you familiar with that matter?
I've heard of it.
You've heard of it. It occurred in the Roodepoort area.
Yes.
Is it a Florida SAPS case or a Roodepoort SAPS case?
A Roodepoort case.
Roodepoort. Do you know the investigating officer as a colleague?
Yes.
Now, it says, the headline reads, bail granted to Umdaduzi Umnisi in shocking murder case of 14-year-old. Murder accused 39-year-old Umdaduzi Trevor Umnisi, charged with the premeditated murder of 14-year-old, I'm going to leave out the minor child's name, was granted bail of 5,000 rands on Wednesday by the Roodepoort Magistrate Court. Is that correct? Have I read it correctly?
Yes.
I just left out the minor child's name.
Yes.
Okay. Now, you agree that a premeditated murder bail application is Schedule 6?
I agree.
You agree? So, the matter before this court is Schedule 5, correct? All we have to do is prove it's in the interest of justice that the applicant be released on bail.
I'm not sure if circumstances to the case you're referring to are the same circumstances as circumstances in this case, because
that's my question, sir.
Being granted bail on 2 schedules and on cases that have different...
That was not my question. We didn't ask for your expert opinion. What I asked is that the matter before this court was Meek's application. It is a Schedule 5 bail application. You agree?
That is correct.
Now, Mr. Mnizi's bail application would have been Schedule 6 because it is
Premeditated.
So the applicant has to prove it's in the interest of justice that she be released on bail. Mr. Mnizi would have to prove exceptional circumstances exist for him to be released on bail. Do you agree?
Yes, I do.
Now, just bear with me, I should get the relevant. Now, it states, the investigator reveals a lack of evidence against Mduduzi Mnisi in the murder case, and that due to the fact that they did not have strong evidence against the applicant, bail was granted in that matter. And it goes on further. There was a spokesperson for the National Prosecuting Authority who stated, as the NPA, we accept the decision by the court to grant the accused bail. The matter will return to court on Friday, the 11th of July. So, one of the fundamental exceptional circumstances in this particular matter, before this, not your worship particularly, I'm not sure who was the presiding officer, but in the Roodepoort court, was that the strength of the state's case was not strong enough to refuse bail in that application, and that the applicant should be permitted to bail based on the strength of the state's case. And therefore, for premeditated murder, the applicant was released on 5,000 rands bail. Are you aware that that was the...
I do not know the merits of that case.
Yes. But the underlying factor that the court relied on in granting bail was the strength of the state's case and the lack of evidence. That is what I'm putting to you.
You are telling me.
I'm telling you, that is the judgment or the reasoning why the magistrate granted bail in the amount of 5,000. Do you now agree that after all of the cross-examination and all of the discrepancies, there is a possibility that the state no longer has a strong case against the applicant?
I don't.
I have no further questions, Your Worship.
Just for academic purposes, Your Worship. Look, you're absolutely, I accept that you say you don't know the merits of that, and the answer is sufficient. Now, exceptional circumstances work this way. It is a list that is not exhaustive, and it is derived from certain factors within the case. That is, it can emanate from the applicant's circumstances or the merits of the matter itself. Now, in the matter that my colleague is referring to, the merits themselves were a problem that the court, upon which it made its decision. And in that instance, the court, in those factors, found exceptional circumstances in the merits themselves. And now, so you are saying the circumstances of that case are not the same as this one?
That is correct.
Yes, and in your opinion, what is the strength of the state's case against this applicant?
It's very strong.
Thank you. I have no further questions.
One further confirmation from the witness, Your Worship. Just one thing.
No objection, as long as it's one.
It's one. It's one, I promise. Sir, do you confirm that the disappearance and the death of the child in the Mnisi matter occurred on the 1st of June 2025, almost 2 weeks after Jayden-Lee's death?
I told you that I'm not familiar with the facts of that case, with the merits of the case. Therefore, I won't be able to give you an answer to that question.
No, but
That's the one question that should be exhausted.
I have no further questions, Your Worship. It was submitted.
The IOL print touch mark P.
As a copy.
As God pleases.
Yes, defense. Of the arrangement made.
Oh, sorry, Your Worship.
Are you done with your questions?
I am done. Worship.
Thank you.
I have stopped.
Sergeant the court, thank you for your time.
Thank you.
You may stand down.
Thank you, Worship.
Thank you, arrangements made.
Thank you, Worship. We will address the court on Monday, Your Worship, as arranged.
I confirm, Your Worship, after the lengthy evidence and cross-examination, we'll need time to consider and summarize the closing argument. So, Your Worship,
Yes.
with no disrespect to the court whatsoever, and I know Your Worship has no control, could I possibly suggest that we start at 10 a.m. so that we enable the accused to be brought timeously? So and also give Your Worship an opportunity to hear her role with the provisionals, etc., prior to us commencing.
I don't know if giving an order is going to assist, because the same thing happened on the last occasion. I was given an undertaking that the applicant will be here at 9 o'clock, only to start at 11. So I can again just request from SAPS to endeavour to please have the applicant here by 9 o'clock. We are losing valuable time by starting at 11 o'clock. Someone is nodding in the gallery.
As a copy, Your Worship, I will be at court at 8:30 in the morning.
You can stand, thank you. Matter is now being rolled over by agreement for closing arguments to Monday. The date is the 28th of July. You are in custody. On that note, the court is adjourned. Thank you everyone for your time.
As a copy.